Yeah.
Yes, good afternoon, everyone. Happy New Year. It's just the second week of January, and I'm sure most of us are adjusting to the new work week. Are you hearing me?
Yes. Yes.
Yes.
Yes. So we are glad that all of you could make it
Yes.
today. I'm Georgette, your moderator for today's webinar, and we are excited to have joined us as our panelists discuss the impact of the new UAE labor laws that will take in effect of the 2nd February. This webinar, organized by Black Pearl, aimed to discuss the impact of new labor laws on employee engagement and retention, as well as how laws will affect workplace across UAE. Once again, I'm Georgette, your moderator for today. I'm an HR international management consultant certified in mental health and CSR, and the founder of Keyword Consultancy. Having handled corporate events, communication, I have more than 14 years of HR management experience. Let me introduce you to our panelists for today, and what better way to learn about our panelists than to hear from them. I'm going to start with Samgita Ramez, who is the CHRO of OmniClouds, a people's person thoroughly result-driven and experienced in global and strategic HR roles. Samgita holds master in both psychology and the human resources and has acquired extensive HR expertise in the business sector, focusing on people transformation, innovation, and organizational development areas. Next, we have Katja Hrusko, an HR advisory director, who is our second panelist for the day. A CXO professional with years of experience with HR IT consulting and the human capital management. Katja is about people and business development, having worked as group consulting director, managing director, and latest group CHRO. Katja currently advises companies in needs of CHRO services such as people strategy, management development, and HR transformation. Also, with us today is Charlotte Ibanez, a legal consultant as well as strategic HR professional. She has spent more than 24 years in the corporate world, helping startup and big companies align policies, procedures, and strategies to attain their business goals. She has been one of the pioneers of the HR department at the Tamuha Group, one of the conglomerate companies under the royal group of His Highness Sheikh Tahnoun bin Zayed Al Nahyan in Abu Dhabi. And finally, we have Ahmed Ragab Al Qutbi, a legal partner who completes our panel. A Part 2 practitioner in the DIFC courts, Ahmed has worked for local, regional, and international law firms in Egypt and UAE for over 14 years. He has handled complex disputes involving multi-jurisdictional employment contracts and has also advised clients on the HR policies and employee retention schemes. For today's webinar, we will be focusing on four main highlights of the new UAE labor laws, which are gratuity and leaves, work models, employment contract, and termination. Each panelist will have an assigned law to discuss changes, strategy of implementing and impacting of the law. We will have a Q&A session towards the end wherein we will go over the question and our panelists will answer them. You have two ways to ask our panelists questions. You may send them in the webinar general chat box, or you can also raise your hand beside the three dots on your screen, the one with the hand and smiley face icon. And a member of our team will unmute you. Again, we highly encourage to ask our speakers questions. We're gonna start now with Sangeeta Ramesh. We will be discussing about the leaves and the gratuity. Sangeeta, the floor is yours.
Yeah, thank you. Thank you, everyone. I'm very excited to be here. It's a pleasure meeting you all. I can see there's a lot of curiosity about how the new laws are evolving and what changes are going to come. And you can actually see some of these changes have already started, and it's all in the positive light. So the recent pandemic was very important for people to realize that work-life balance and well-being of employees is equally important. And this is how the new laws are customized, I would say more focused on emphasizing on employee well-being. So one of the recent things that we've noticed is the holidays have now, the weekends have shifted between Saturday and Sunday. We all enjoyed a long Friday and a lazy Saturday. And now it's still the 2 days are now moved to Saturday and Sunday with Friday as a half a day. And this is only for the public sector. However, there's an indirect push for the private sector to embrace it. The UAE government is also encouraging us to embrace this change because the schools have now changed, the people with whom we interact, the government sectors have changed, and we are aligning more towards the Western cultures, embracing the new norms and aligning with the global markets. While this is really interesting, it's going to be very different because some of the GCC countries are still working on a different, work week. So while we're still adjusting to working on a Friday and not coming to office on Sunday, we now have the new announcement which is going to come on February 2nd. So the new labor law is focused more on employee well-being, and the emphasis is more towards employee wellness. And there are many new aspects that are being addressed. And now I'm going to speak a little bit about everyone's favorite topic, which is the leaves. This is something that all of us look forward is the holidays. And the recent laws have been very generous. If you look at the maternity laws, we've always had 45 days of paid leave. But now there is a recommendation to move this to 60 days. So you will have 45 days of full pay leave with another 15 days of half pay leave. And if a mother gives birth to a special needs child, then or a child of termination, you still have 30 days of an additional leave. So these are very encouraging for young mothers and especially the first time mothers. But at the same time, people who are always used to the conservative pattern of maternity leave, it comes as a welcome move in this pandemic. It gives them more time to spend with their newborn. However, there are no changes in terms of the nursing breaks or other provisions that already existed. If you look at paternity leave, these are some of the new changes that are going to come. The recommendation is for 5 days of leave. Some organizations which are not very conservative already have these provisions as a part of their policy. But now the government has emphasized this, so it's going to come out as a new law. Sometime back, there were a lot of requests from people asking for bereavement leave or compassionate holidays. GCC countries, some of the GCC countries already have vision of compassionate leave. So if someone dies in your close family, then you have paid 3 on the relationship. What we're looking at is there will be a 5 days of leave in case it's a death of a spouse. And there could be another 3 days of leave if it's a parent, child, sibling, grandchild, or grandparent. Sometimes it's really important to define these relationships so that your policies are very clear. There is nothing in the law that stops us from giving additional leaves. So if you want to have a standard policy of 5 days of mourning leave for any of your close relatives, then please go ahead and do that, because the intention of the law is to make sure that employees' rights are protected and at the same time there's a good work-life balance. So I just want to share some more details around how you can incorporate these new laws. Can we go to the next slide, please?
Yeah, please.
So these are just some of the ideas that progressive companies include. So you can have some new leave types like adoption leave, because childless couples who want to adopt a child, you want to give them a leave, and this is not something that's very frequent. So we encourage companies to include these kind of holidays in their plan. You can also have something like a birthday leave. It's just a kind gesture for people to have new holidays, and then a community service leave. So there are different leave categories that as a company you can decide to give based on your policy and your vision. So if you're a company who are promoting an NGO, or you want to support a cause, you can have a paid leave for employees to promote that. So additional holidays are always welcome, but you want to make sure that these are meaningful and at the same time impactful. So please feel free to include these lead types. And in the pandemic, we have really seen that even the conservative companies have embraced the new norm. They are moving towards the digital. There is flexi working hours. There are people who are working from home and remote. You never thought that we could have these kind of setups done 10 years back, but now this has become a trend. And even the most conservative companies are following this. So please feel free to include something that's really more trendy and more attractive for employees. At the end of the day, you want to make sure that the retention is there and the employees are engaged. The fundamental thing when you're working out on these new policies or new leaves is to make sure that it's all standardized. For example, maternity, paternity, sickness leave, or bereavement leave, or compassionate holidays, whatever your leave policies are, please make sure that they are standard for all. So it looks fair. So you have the same approach and consistent approach across all employees in the organization. The second thing I want to talk about is on the hybrid working model. So not many companies are comfortable with remote working. Despite the pandemic, there are still some companies who are hesitant about trying this model. So for those organizations, you should start off with hybrid working. You could have partly working in the office and then try something working from home. We tried the hybrid internship for the first time, and it worked really well for us because we could attract talent from Europe, from Africa, all over the world. So this was something that we as a company found it very successful during the pandemic. So I encourage all organizations to try and embrace this model on hybrid working. So we always used to talk about work-life balance and how to compartmentalize. But now things are changing and it's all about work-life blend. It's a simple reason. When you come to office, you always think about your family. You cannot park your family somewhere. If there's an emergency or you want to attend to a school event, that comes first, isn't it? And at the same time, you also think about work when you're at home. You're having a family dinner and there's an important call to attend. You embrace it. It's a very natural process. So there's nothing to feel guilty about it, because at the end of the day, you're both. You're a parent and an employee at the same time. So what we're talking about is a work-life blend on how to manage these expectations and be easy with us. And that's all about mental health and well-being of people. The last aspect is on people data and analytics. Every organization is very different and unique. You have your own people, you have your own data, you have your own trends. So it's very important to have insights and data that talks about your company and not what other companies are doing. It's always good to see the best practices from other organizations, but every organization is unique. So unless you have a data of how many people are working from home, how is your productivity, all those analytics, you will not have the data points to talk forward. And one of the things that as HR professionals, we really need to remember is having these data points whenever we go for meetings. So this helps us to make meaningful decisions. So a lot of these laws are coming in force, and if you look at it, even the gratuity is going to change. However, we still need to see how these are evolving. So sometime back, we used to have in the old law that if somebody does gross misconduct, they're not eligible for gratuity. And it was slightly different depending on their contract and the duration. But now we are expecting a lot of standardization, although the official announcement is yet to come. But we are hoping that this new laws are going to be a game changer, especially on employee engagement and retention. So wishing you all the best, and I hope in coming days we are going to see how these work practices are going to evolve. So I'll now ask my colleague, friend Kaja to take over. She's going to give us more insights on contracts, the next part of it, which everybody is really curious to hear. So Kaja, over to you.
Thank you, Sangeeta, and also thank you, Georgette, for the introduction. So can you change the slide, please? I'm talking about work models today. There we go. So let me start by introducing myself. Hi there, my name is Katja Ruskova. Like Georgette already said, I work independently as an HR advisory director, helping clients with HR transformation, strategies and management, development and mentoring. And I have been so fortunate to have worked all over Scandinavia, Europe and the Middle East over the span of my work life. And I have seen various work models during my time. And I was thrilled when I heard that the UAE is now allowing us to work with several models, either full-time, part-time, flexible, or temporary. Not only will this allow us and the employees to get a better work-life balance, like Sangeeta just mentioned, but it will also help companies and startups to enhance and grow their businesses in a profitable way. So a lot of free zone companies are already working this way, basically because it's mostly foreign companies that are in the free zones, and they are aligning their existing processes and work models with the way they work from Europe and the States into the Middle East. However, this also applies to the private sector and to the public sector here in the UAE now. And this, combined with the new laws regarding working multiple jobs, which we will hear about later, it definitely adds an additional flavor to the employee experience. And what does this mean in real life? Well, full-time sort of speaks for itself. You will work a normal work week of a defined hours as per your contract, whether it's a 5-day work week or it's a 6-day work week. So part-time can be anything based on the defined numbers of hours as per the contract. Flexible is the most interesting part, at least that's my taking on it, as you can work your entire work week in 3 days and then have 4 days off. It is possible now, but of course it has to be agreed with your employer. This could, for instance, apply to people working in shifts or for people working in retail. For other businesses, it may not work. But you could also choose to share your job with another person, work less, and then share the salary for this job. But again, it has to be agreed with the employer. And not in all circumstances is this applicable at all. But at least the law gives us the right to do so legally. The temporary jobs could be beneficial for both parties. It could be a seasonal role, for instance, for Christmas, where the need and demand is large, or based on an immediate need for a manufacturer with a huge bulk order. So if you're working a part-time role, you may want to take up some extra work for a period of time. And this is now possible, but in order to do that legally, you would need to get a permit from MORE and non-objection certificate from your primary sponsor. And this can be obtained for 1 year for the sum of 100 dirhams and a 500 dirhams approval fee. So a total cost of 600 dirhams per year. I need to underline that the contractual part of the new changes are very important here to avoid circumstances where the processes and the procedures could fall between two chairs. I mean, if you're a company wanting to offer part-time, flexible hours and temporary jobs, then please ensure that your contracts are updated and reflects the new working models. It is also important to update the expected number of working hours in the contract, as you cannot just hire a person to do 20 hours per week, and then the next week you cut it to 2 hours. That is not applicable. The employees will still require a notice period for all changes to the employee contract. That's UAE law as well. Last one, but not least, when working with these new models, you need to make decisions around medical insurance, for instance, benefits, bonuses, and non-competition clauses in the contracts. As it is now, medical insurance will always be a responsibility of the primary sponsor. But as an employee, you may want additional benefits from your second job. That is something the organizations need to be able to cater for. And for the non-competition clauses, I mean, a lot of employees today have these clauses in their contracts, not allowing them to work for similar employers. And of course, that needs to be moderated and if not taken out of the contracts. So please ensure that you have that in place for your employees, opening up for working with the new models. And you also need to ensure that your contracts are reflecting the entire employee life cycle. So after COVID came into the picture, we have seen a lot of new ways of working. And you can now work remotely, like Sangeeta just said. You can work in the office or you can work on a hybrid model. And as an example, perhaps 3 days remote and 2 days at the office or on site. And of course, this is not applicable to all sectors and industries, but for those in play, you will need to update your processes and policies around this to avoid disappointment and legal cases. So this is all for me now, but thanks. Please ask any questions you may have at the QA session at the end of the webinar. And thank you so much for now.
Thank you a lot, Katja. Thank you for really clarifying and giving all this information. Now I would like to invite Charlotte. Charlotte, can you talk and give us more clarification regarding all the employment contract?
Yes, thank you, Georgette. Good afternoon, everyone. It's a great privilege for me to be part of today's event. And I would like to take this opportunity first to thank the entire team of BlackRock for hosting this very timely and relevant webinar. So for our discussion today, it has been discussed already that UAE made its first major overhaul for 40 years of the labor law. Federal Decree number 33 of 2021 repealed the current law, which is Federal Law number 8 of 1980, which is due to take effect on 2nd of February 2022. So the goal of the Ministry of Human Resources and Emiratisation in making this significant changes in the law is to attract best global talents and, of course, provide a competitive work haven for locals and expatriates. So it will apply to all companies and employees in the private sector in the UAE, including its free zones, except for Dubai International Financial Center, or DIFC, and the Abu Dhabi Global Market, or ADGM, which is, of course, they have their own employment law. And the new law makes extensive reference to issues that will be addressed in the implementing regulations and other directives that are not yet issued. But of course, we are anticipating to receive it this year. So one of the salient features of the new law, which I'm going to discuss now, is regarding employment contracts. It is the abolition of unlimited contracts. We know this, that under the old law, contracts are either limited or unlimited, but under Article 8 of the new law, unlimited contracts are to be abolished and replaced with work contracts of a fixed term on the same conditions with consent of both parties for a similar period or less. So in the event the term of agreement is extended or renewed, the new term shall be treated as an extension of the original term and shall be added to it when we are actually calculating the employee's overall length of continuous service. So what's the deadline for drafting of the new employment contract? So in compliance with the new law, all employers in the private sector shall be required to replace their current employment contracts with limited contracts. So employers have a maximum period of 1 year from the date of the new law's implementation, which is 1st Feb 2023. Since we are talking about employment contracts, how do we, as HR professionals, managers, business owners, and executives of SMEs, startups, and other businesses go about these changes? We all have to make the needed amendment, as emphasized by Katja earlier. We need to make amendments into our employment contract templates, company policies and procedures, and maybe your own business processes. So we came up with a checklist just on the key changes in the law. So on the next slide, you will see that these are the checklists. We'll just have a quick rundown on what we need to amend. So those that have been discussed by our highly esteemed co-panelists, I will no longer tackle that, but only give you some pointers on other topics. So in the checklist, first we have the fixed term contracts, employment contracts, which we already discussed. Of course, the flexible working hours and overtime, which was discussed by Sangeeta. You also have the new work models, which was discussed by Katja. You also have to amend weekly rest days. You also have to have the probation period. Now, please note that here, the employer and employee are required to provide 14 days notice of termination. So the employee is required to provide 30 days notice if they wish to take up a new employment under a new employer. So if they do, then the new employer in the UAE is also obliged under the law to compensate the current employer in respect of the recruitment cost. In the event that the employee on probation resigns and returns to the UAE within 3 months from the date of leaving, the new law indicates that the new employer is again responsible for reimbursing the original employer for the recruitment cost. Leaves extensively discussed by Sangeeta. We have to amend that. Then non-disclosure and non-competitive clause, it was mentioned also by Katja earlier. In non-compete clause, the same legal contours you can see of the old law imposing post-termination restrictions, except that in the non-compete clause, it may not exceed 2 years. So previous prevailing practice is 6 months, maximum of 6 months. It remains to be seen, however, if this executive regulations will provide any further clarity on its enforcement in the future. Then, of course, you have the disciplinary sanction and suspension, which will be discussed later. And of course, you have retention period and passports. Now here, employers are required to retain employment records of employees only for 2 years after the termination of employment. And as you know, with regards to passport, we are not, employers are prohibited from retaining it. Then next, we have to amend equal opportunity, equality in wages, currency deduction. Now here, employers should ensure their current equal opportunities policies are robust, wages the right for female workers to be paid the same salary as male workers if they are in the same role or another role of equivalent value. Article 27 of the new law will set a minimum wage. This is actually an unprecedented move for the UAE. So regarding currency, wages can be paid now in UAE dirhams or any other agreed currency. Now, on deductions, it is allowed to have salary deductions, but it is capped on 20%. Now, if there are multiple deductions, it is capped up to 50% of the wage. New developments on discrimination and harassment. The new law makes it clear that discrimination on the following grounds: race, color, sex, religion, national, social, or origin, or disability that reduces equal opportunity or prejudice equal access to or continuation of employment and enjoyment of rights. So the new law expressly prohibits prohibits sexual harassment and all sorts of bullying. So the responsibility of employers in this regard is to review their current policies and grievance mechanisms to ensure that they are fit for purpose. Now, if we plan to employ youth, we need to amend employment of we need to have a provision on employment of teenagers. Then, of course, we need to amend also the termination provisions in our contracts, which will be discussed later. Summary dismissal, exemption from judicial fee. This is probably not a part of the contract, but good to know operationally. So the judicial fee exemption now is up to 100,000 dirhams. Relief applicable to all workers that includes all stages of litigation and execution and requests submitted by employees. End of service gratuity, as well elaborated by our co-panelists. And then death of employee. Employer should pay the deceased employee, the deceased employee's family, all outstanding dues within 10 days. And then, of course, lastly, labor disputes or labor fines. Now, the new law updates the existing penalty regime and provides for additional penalty. Generally speaking, penalties for non-compliance are more harsh under the new regime. So note in the checklist, exemption from judicial fees and labor fines may not be reflected as part of our employment contracts, but may be good to know for business operation purposes. So these are the provisions or terms that we need to reflect in our employment contracts, and of course mirror the same into our company policies and procedures. Hence, it's better to start now, better to start earlier to do the amendments, so that when the ministry issues the implementing regulations this year or before the deadline, half of the work has already been done. Of course, in any change management within any organization, communication with stakeholders is the key. Thank you.
Really, Charlotte, appreciating all this clarification, especially now that all employee and employer are having all this misconception. Now, we would like to move to our final panelist for today, Mr. Ahmed Ragab Al-Qutbi, who will be talking and telling us regarding all the termination. Ahmed?
Thank you, Georgette, and welcome everyone. I'm going to talk to you about the termination, and I've focused my presentation on this specifically for the changes in law. I'll leave a longer part of my presentation for questions and answers, because I'm sure many of you would have a lot of questions regarding the application of the law. So termination under the UAE law is either with notice or without notice. So on the with notice termination, the old law anticipated that a limited contract cannot be terminated unless agreed by the employees. So if an employee and employer did not agree a specific notice in their contract, and that was not a requirement for the contract, the employee or employer termination of this contract would be a violation of the law. In many instances, especially on the non-high skill employees, such termination would cause a ban. And for the high skill employees, like with a university degree, this ban can be removed much easier. Now, both limited and unlimited contract are having the opportunity of termination, and a notice is mandatory. So you have to put a notice into your contract. For unlimited contracts, previously you had to agree some notice, and if you don't agree a notice, it was assumed to be 30 days. Now, the old law included 6 months as a maximum notice, which was applicable earlier by the Ministry of Human Resources. Then a few years ago, they stopped allowing employers to include such 6 notice period, and they were allowing only maximum of 3 months notice. But this was not in the law, this was just general practice. Now it's capped at 90 days. And interestingly, although the law required every employer to change their employment contract into limited contracts, and they have given 1 year to do this. So by 1st of February 2023, everyone should be on limited contract. The law allowed the minister to extend this period for a number of times, and it allowed the employer to utilize the difference in gratuity if they kept the employment unlimited and the minister decided to extend. So my advice to our different clients who asked about this when the law was issued, we told them simply, this law is issued in September, so you already have around 4 months until effective date. Then you have 1 year to change the employment. So unless you plan to terminate your employee, if you plan to keep the employee, just at the time of visa renewal, change their employment contract into limited. This way, you save your fees because there is no additional fees. Just when you're renewing the contract, you do it. If you are under Mohri regulations, so although the labor law includes a 3-year period as maximum, but you would find that all your employment contracts are only 2 years period because you have to renew the visa each 2 years. If you are in a free zone, definitely other than the DIFC and ADGM, then it will be automatically 3 years. So the gap will be much less. Now, let's take the assumption that the minister does not extend this period, and on February 2023, it has to be limited. Then the only real change to this would be for the gratuity. So anyone who is less than 5 years in your company will now be entitled to the full gratuity, and you will not enjoy the 1/3 during the first 3 years and 2/3 from 3 to 5. You have to pay the full gratuity. So our advice to companies right now, put a provision for the full gratuity from now on. One more interesting thing for those employees who have spent some time with the employers on unlimited contract, and the employer does not elect to change the contract right now into a limited contract, the law have specified number of notices of 30, 60, and 90 days based on how long the employee has served the employer. So for any employee who has served less than 5 years, they have, either party has to give 30 days. If it's more than 5 years, less than 10 years, then it's 60. More than 10 years, then it's 90 days, which gives some flexibility in dealing with this matter. One last thing for termination with notice is regarding the period of the notice. In many instances, we have found employers taking longer period for themselves and shorter period for the employee. So they say, If I want to terminate you, I give you 1 month. But if you want to terminate the contract, you give me 3 months, for obvious reason that an employer would need some time to recruit. The new law said it has to be equal. So it's 1 month for all, 2 months for all, or 3 months for all, unless it's more favorable to the employee. So this is a game changer. The other termination is the termination without notice. If you can change the slide, please. Termination without notice has not changed tremendously. It's almost the same as before. So Article 120 is now on Article 44 with more tweaking and more fixing of vague discussions. So previously, you had to inform the Labor Department or the Mohri 48 hours prior to doing anything with regard to Article 120, or if it's severe misconduct. Now it is clarified that it's 7 working days. So before, it happened that 48 hours is all holiday or anything, and it's useless. The other thing is, although the old article required a written investigation, the new article required written investigation and requested that you provide the employee with the results of this investigation. And in number of the points, it included systematic way of termination. This systematic way is not new. It was already there, but not in the body of the law. It was actually in the model regulation issued by the minister. And technically speaking, it was not applicable until you have actually adapted this model regulation and notified Mohri with it. Now, the law allowed you to adapt regulation and did not clearly and specifically told you have to notify Mohri with it. It just noted that you can put it on a wall or put it accessible to everyone and prove that it is notified to them. One last interesting point on the termination without notice and termination reasons is that the law recently adapted a new reason for termination, which is economic circumstances. For a very long time, a lot of employers would terminate an employee until this is because of economic circumstances, this is because the company is not doing well, and courts were not taking this as a valid reason for termination. Now the law allows such thing. I'm not sure how the court will interpret this. We advise our clients usually that the company doing less well than before is not a reason for termination. It has to be, the termination has to be for reasons that the company will actually close down. It is not clear how it will be interpreted later on with the ministerial decrees and with courts, but we're yet to see. I think I'm running out of time, so I'll pass to Georgette again, and I'll be happy to answer any further questions.
Yes, thank you, Ahmed, for identifying and clarifying the difference between the termination with notice and without notice. We started to receive lots of questions from our audience. I will go randomly. I guess the first question is to you, Sangeeta. We have someone asking, do you think that the implementation of these various kinds of leaves would help in increasing the retention of employees?
The intention is just to make sure that employees are retained, and at the same time the holiday plan or the leave calendar is attractive. So regardless of the law, every organization want to have their own retention strategy just to make sure that their holiday system or work-life balance is really attractive. So we have seen this, and you must have even noticed New Zealand going with 4-day week, and they had some successful strategies and good stories talking about how these changes really promoted work-life balance. So we hope that these new laws will definitely make an impact. And at the same time, you need to make sure that you're doing all of these changes with the right balance. So, for example, you cannot ask, give 4.5 days a week and at the same time make them work in the night time, So it's all about balance and making sure that you're aligned with the spirit of the law. And then this is going to be really attractive.
Yes. Also, another question regarding the leaves. Apparently, it's a very interesting topic for all those attendees, and especially for all the employees and also the employers. So another question, it will be also to you, Sangeeta. What are the implications that there are no longer distinction of annual leave between those who are now new and those who have stayed longer in their company?
Okay, I think the most important notice the change that we have seen is the standardization. So now there not going to be any distinction between the years of service or the race or the background that you come from. So it's a standard 60 days of maternity leave. You like it or not, it's 45 days full paid and 15 days with half pay. And in line with making the equality, if you have a special need child, then you have an additional 30 days of paid leave. So these laws never existed before. So now the focus is more in terms of having the standardization and ensuring that everybody is treated fairly and equally. So this is the spirit of the law.
Charlotte, another question.
Yeah.
What do you think is the rationale behind removing unlimited contracts?
I believe that the change in the new law is to align the current employment, the duration of the employment contracts with that of the standard employment-based residence visas. So if you look at it carefully, although only limited contracts will be in existence, the law, however, allows renewal or extension of contracts. So somehow, in effect, it still has the flavor of unlimited contract.
Yes. How would part-time temporary employee affect the employee engagement and the workplace culture?
Actually, is that for me as well?
Or if any
Yes.
of our honored panel would like to answer.
Actually, it will work in reverse. I don't see the point that there will be any changes because the more that you provide leave more time for employees, I believe that they would have more time for themselves, less stress, less and they will be more efficient. Actually, there's a study that has been conducted where employees are more productive in that sense if you provide them more time.
Yes.
And I would like to add to that as well. With a Scandinavian background, I was quite surprised to see that I think it was Iceland or the Faroe Island that recently said that we only had, they would want to implement a 4 days work week. And that basically meant that you would have an additional day to yourself. But then they had conducted a research on this, saying that the productivity would actually be much better if you gave time to your employees to do their own thing. And with the part-time jobs here, yes, that makes sense. And in a way, you are your own boss in terms of working hours, or you can be. Which makes it possible for you to have a perfect work-life balance. And I think that is very important. I introduced this to my employees 10 years ago when I headed up an IT consultancy here in the UAE. And at that point, they were not ready for it. They could not understand that that thing with working from home. They wouldn't be contactable, but then I took it away again from them, the privileges, and now they are definitely ready. They have shown a lot of effectivity also during COVID. So you just need to find new tools and new ways of working together.
Yes, Katja, we have a question from the audience. As an HR professional, what do you think are the roles that can be converted into part-time temporary work?
I'm sorry, you froze in the middle of the question. Can you repeat it, please?
Yes. Now it's better?
Yes.
Yes. So as an HR professional, what do you think are the roles that can be converted into part-time from the normal temporary work?
It could be, for instance, in retail sales. It could also be in consulting. There are, of course, a lot of industries where it is not applicable at all, but those could be some of them. I mean, representatives, salespeople, but of course their targets would need to be specified to them only. So there will definitely be needed some work around these roles, but if you carry the will in your heart, you can get there.
Yes, thank you. Ahmed, we have a question if you would like to answer.
Sure.
How would limited contract affect the payment? If any employee leaves before the completion of the contract, do they have to pay a fine, even if they have worked for the organization for more than 3 years?
Well, under the old law, in limited contracts, if an employee left, there was a specific compensation, which is half pay of 3 months, which basically 45 days, or the remaining of the contract, whichever is less. Now, both employee and employer has to give a notice under the contract, because now there is no limited and unlimited. And if someone does not comply with the notice, then they need to compensate with a compensation equal to the number of days they have not worked. So for instance, if an employee's notice is 60 days, they give a notice or they decide that they're not giving a notice at all, they pay the 60 days or any time that they have not served. But in this regard, the law obliged the employer to allow the employee to search for a job if the termination is coming from the employer side, so he can take 1 day for job interviews and things like that.
We have an additional question, and it will be unfortunately our last question that we can take it from the audience. Also, Ahmed, it's for you. So if someone who was initially hired as a part-time worker gets converted to a full-time employee, when would their probation period start?
Well, the full-time employment will not start a new probation, because the simple rule is an employee can be hired on probation 1 time only. So unless there is a change in the role, so for instance, I hire someone as a secretary, then during the course of their working with me, they take a degree and become a lawyer. And then now they are hired as a lawyer. Under different jurisdictions, the law allows me to put them under probation for this new role, which is completely different than what they had been doing before. But if it's the same thing, or it's like a promotion for the same thing they are doing, so I cannot put them again under probation. Probation is to test whether the person is doing the job right, whether the person is suitable for the organization. So if I hired you, I already know whether you are suitable for the organization, and I wouldn't promote you unless I know that you are capable of doing it.
It's really hard to answer all of your questions on the new labor law in an hour, but that's it, all we have for today. And to our panelists, thank you for your time. And to our attendees and viewers on various social media channels, thank you for staying with us. I hope you've picked up some insight that can be useful for your organization. It was a pleasure hearing everyone's thoughts, and we hope to see you again in future. Thank you, everyone. Bye-bye.
Thank you.
Thank you.
Thank you.